This is an examination of the hidden human condition.
This is the Hidden Killers Podcast.
The Hidden Killers Podcast.
With Tony Bruschi.
We are talking with criminal defense attorney Jack Rice today. He's a nationally recognized and award-winning criminal defense lawyer, one of the best out there. So I'm very excited to have this conversation with you, Jack. Something that I think a lot of people don't really consider when they think of your line of work is the handling of the clients that you deal with on a regular basis. I'm sure some are right there, active and ready and competent to take part in their defense. Others, not so much. And Lori Vallow Daybell seems to be far more than a handful. I do not in any way, shape, or form envy those who are trying to represent her in court, especially on Tuesday, where she did not want to return to court. It really just seems like they have their work cut out for them if they're able to keep her coming into court day after day. Can you talk about that and the difficulties of handling a client like maybe a Lori Vallow Daybell that they don't really, go along with the show as they should?
Handling clients is a massive part of my job. Mm-hmm. And not only when you're building up into trials or negotiating settlements, but also when you're in trial itself. I mean, it really highlights a certain point, and it highlights that a jury misses nothing. Mm-hmm. They're watching what she writes down. They're watching the smirks that come out on her face when she looks at her lawyers about something she doesn't like. And that comes out, and it's very, very clear. They're looking at the shoes that you wear. It's really quite extraordinary. And when you look at some of the testimony that has really come out in the last couple of days, Tuesday was particularly brutal in terms of one of the detectives laying out some information. I understand in some ways saying I can't be in the room. I do appreciate it. And yet at the same time, I think a jury looking at a case like this is going to say something else. They're going to say, I came here because of you, or at least because of the government saying you did something. They took me out of my life. The least you can do is be present alongside me as we make this decision. I think they could easily hold that against her if she doesn't appear. And I think that's really part of this issue.
I mean, could this, is there anything out there where she could find a way to not appear at other portions of this? I know some of the language was rather interesting that Judge Stephen Boyce has even said, citing one term of a defendant being bound and gagged to be forced to stay in the courtroom if they need to exercise that. But is there an out for someone like this who obviously is not very mentally well? And at that point, should she even be standing trial?
Well, there's no question about this. I mean, it's interesting to me when you get a judge who says that, and there are debates about this as they were arguing about the right of a client to be present for something like this, for a defendant to be present for something like this. I mean, let's sort of dumb this down for just a second. Let's think about what we've been seeing over COVID. There's been lots of time on whether or not somebody could actually be on video, whether or not it could be done that way. And what we started to see was these things have started to develop over time, and we're seeing people starting to appear on video. This has happened not that long ago on some pretty nationally covered cases. And so that's the possibility. However, that being said, when you have a judge talking about being bound and gagged before a jury, I think a judge, that might be quite a bit of hyperbole, because you do that to a defendant. I don't see under any circumstances how you could possibly, and I mean possibly, say that somebody can actually give them a fair trial. I think that's a due process violation in many, many ways. And the problem is this judge also doesn't want this to go to appeal. What this judge wants is a really clean, really simple trial without any problems. So that way, if it's not guilty, it's over. If it's guilty, they go down and they don't take it up, and they don't have the ability to bring this case back to try again. And there's everybody in the room who's very conscious of that issue. The judge frequently, first and foremost.
And that's the interesting thing with this whole case. I'm starting to wonder, one of two things are going on here. Either she is mentally cracking so much that she really just mentally can't be there and this thing shouldn't be going on at all right now as it is with her mental state. Or she is well aware of what's going on, and as she has through most of her life, found ways of getting what she wants done, whether it be husband 1, 2, 3, 4, or I don't know what was Chad 5. I don't remember at this point. Or whatever she wanted, she could manipulate people to do it. And it became probably second nature to her. So the fact that there would be pushback against her is probably somewhat shocking, even though she has been in prison now or in jail for quite some time. And is this part of her strategy? Certainly, I'm not assuming this is part of the legal strategy of her defenders, but is she just going rogue on this and trying to create issues where this could go to appeal, where there would be arguments made because of the chaos that she creates?
Well, it is a wonderful question. One thing we can say is we can say she has absolutely been found incompetent previously.
Yes.
So we can say that objectively. What that does, though, is that really does in some ways change this case, because we're always going to have to reconsider the question of competency. And I know that her lawyers have done this previously, too. But the problem that you have is, for people who don't realize, you need to understand the intensity of a system like this and what it is to be in custody and have your life on the line. In this case, there was a question for a while there of the death penalty. So there's that piece, or life in custody. Or if you want to pull back even further and say, people are making allegations that you murdered your children and you are already precarious. So you add all of those things up. And I think that, let's add the national spotlight that's been on this case now for years.
Yeah.
And so there is an enormous amount of pressure on Lori. And I think there's probably an ongoing question of, do we do another psyche eval right now to see if she's even competent in order to continue? Because that's going to be an appellate question too. The problem you have is, once you actually seat a jury, once a jury is impaneled, that means they've all been sworn in, you've chosen the jury, you got your alternates in place, and they're seated. This is when double jeopardy strikes, if you will. This is when the decisions have to be made. But it's very difficult to have a mistrial or say, hold on, let's see if she's competent, because you can't just pull her off over the lunch hour and just have her talk to somebody and say, what do you think, doc?
Yeah.
Because it's far more complicated than that, too.
And that's where I am just very curious as to where this is going. Before it even started, I was saying, I asked everyone that I talked to, every attorney that we had on the air, every psychologist that we had on, it was the question of, do you think she will make it through this trial? Everyone saying yes. 2 days in, there's already these cracks that are happening.
But the thing is there's history here too.
I'm not surprised at all.
Yeah, see, Tony, I'm with you, because I know there are people who will say, and I'm not also surprised. I've seen judges do everything they can to keep people who are precarious sort of on track. Yeah. People who might be frankly incompetent on track. Yeah. And what I mean by on track is you keep that trial going. The problem is that's not how the system is supposed to work. You're supposed to understand what you're being charged with. Mm-hmm. You're supposed to be able to actually help in the defense of your case. You're supposed to be in a position to understand the difference between right and wrong. And we know that she's already been found incompetent. Yeah. Understand what the standard for that is. Yeah. I mean, I've seen this as a former prosecutor, where there would be somebody who would come in with an IQ of like 55. Mm-hmm. Now, contemplate that. And we would send them for a competency evaluation, and they would come back as competent. Yeah, so, which is astounding to me for a lot of different reasons. But I think it's a legitimate question when you see somebody like a Lori Vallow, who has spun out of control in the past and so easily could spin out of control. Maybe this is one little twist. I'm walking into a jail not long ago. This is how hard it is to get in. And I only bring it up in the context of the pressure. Sure. I got to go through the deputies at the front desk. I get on an elevator that has no buttons. They take me up to a floor that lets me off, that walks me down a hallway to another door that has locks on it that they have to open from somewhere to let me in, to get through another set of metal detectors, to go to another door that unlocks, that takes me to another elevator that has no buttons on it, that takes me to another floor that lets me off at a door that they have to open, through another hallway, through another door where I sit in a concrete cell. Now, contemplate being in that space for 2 or 3 years.
Yeah.
And you realize what this could do to somebody. And I'm talking about somebody who may be generally emotionally and intellectually and psychologically balanced before they start that process.
And then do that to someone who already is not balanced, and then look what you get. I mean, I in no way have any sort of sympathy for Lori Vallow Daybell, but as I'm watching this and as it was leading up, I'm just looking at this going, this trial is much more for everyone burning the witch than it is for, I think, finding justice. Because even if you do find justice, I don't think everyone so desperately, I think, wants her to wake up and see what she did and feel the emotions of what happened. But some people can't do that. Some people just don't have the ability to do that. And that's something hard to accept.
And you know what? That is actually one of the massive challenges. I've seen this so many times. I've had to deal with this so many times in my career, where everybody in the room is this way. And I'm including the prosecutors. I'm including the judges. I'm including everybody in the room, the officers, everybody else, and sometimes jurors too, where they're looking at this in a very sort of black and white, relatively simplistic way, where what you have to say is, you need to understand where this person is and why that matters so much.
Yeah.
And it's hard because it's a complex question. Yes, I understand the allegations are horrific. They make my stomach turn, and I can do just about anything.
Sure.
And yet at the same time, the ability to say, hold on a second, when we're talking about due process, when we're talking about competency, when we're talking about diminished capacity, and we have to really look at how that works. It takes a very mature approach to say, how do you set aside the horrific allegations to look at just this myopic, narrow issue of how does this and what is the lens through which this person sees the world? That takes effort to get people to do that. And I'm including judges, prosecutors, cops, juries, and everybody else.
Is there, what would it take for this thing to end early, or where to be a mistrial, where it says, they say, you know what, she truly cannot be here? Would it be her kicking and screaming more and really not wanting to go in? What would it take for them to say, she's not okay? She's not mentally capable of doing this.
Tony, you got it. What you're going to see is a psychotic break.
Yep.
And what you could have is that where it's going to come from is not in the middle of the trial. It's going to come on a morning when everybody's waiting, and all of a sudden, deputies from the jail are going to come in and say, Your Honor, we need to have a conference off the record and in chambers or sidebar or however they want to do it. And they're going to come in and say, we got a real problem here.
Yeah.
And the problem is that this judge desperately wants to keep this thing going. But if this judge is decent, this judge also needs to recognize that this process must be protected. And there is a singular person in the room who has the true authority to do that. And I'm hoping that in the event that were the case, that this judge would also remember that. You and I are on the outside of this. If this is complete and utter manipulation, I understand they have to look at that too.
Sure.
But it's really important.
This is an examination of the hidden human condition.
This is the Hidden Killers podcast
With Tony Bruschi.
Jack Rice, nationally recognized award-winning criminal defense lawyer. Thank you so much for joining us. You can check out his website at jackrice.law.com. If you like this program, be sure to press subscribe wherever you download podcasts. You don't miss any breaking updates and discussions on the cases that we're following for you right here. My name is Tony Bruschi. Stay with us.